This is the second episode of our video series on preparing for the ABA arbitration tournament. And I'd like to talk for just a minute about the manners that are expected of law students during this tournament. Even though arbitration is not quite as formal as a courtroom, I think you will find that this tournament has some rather formal requirements about the way law students conduct themselves during the competition. So by all means, take the initiative when the room is first settling and organizing to introduce yourself and your co-counsel to the arbitration panel. This should happen well before you begin your opening statement, and it is the opportunity also to take care of one or two preliminary matters that you would like to address before the competition rounds begin. Now, it is important that law students, according to the rules, are to remain in their seats during the presentation. However, if you would be more comfortable or you think you would be more effective standing on your feet, either at your table place or perhaps in front of the arbitration panel using the table set up for the witness seat, that's perfectly fine. And it is entirely up to the arbitration panel. So by all means, raise it as a preliminary matter to the arbitration panel. Just say something like, I'd like to request of the panel, if there's no objection, that I stand at my place during my opening statement presentation and during my conduct of examination of the witnesses. This is usually entirely acceptable, and it is good manners in this tournament to ask the arbitrators first. If you need to show a piece of paper to a witness, by all means, ask the arbitrators if you may approach the witness. This is usually granted as well, but it is an important part of the control that you must recognize that the arbitrators are exercising over the entire round. Take the opportunity to acknowledge turning points in your presentation. If you are, for instance, conducting a direct examination of a witness, you've reached your last question, the witness has given the last answer, turn to the arbitration panel and say, we have no more questions of this witness on direct. Before your cross-examination, recognize that, with a little touch of reality here, you do not know the witness you are about to cross-examine. In fact, in the circumstances of this tournament, it will be a law student from a competing school. So introduce yourself to the witness. Mr. Smith, my name is Andrew Caffey. I'm the attorney representing the respondent in this matter, XYZ Inc., and I just have a few questions for you this afternoon. It's a nice introduction of yourself, and it's a nice lead-in to your cross-examination. When you are finished with your secondary witness on direct, by all means, signify this to the panel by saying something like, we have no more witnesses to call for the presentation of our case. At the conclusion of the summation, thank the panel for their attention and by all means offer to answer any questions that they may have in the time that you have remaining. These are courtroom manners, and as I say, the arbitration is not as formal as the courtroom, but in the circumstances of this tournament, you are expected to yield and to ask questions and ask for the directions and preferences of the arbitration panel.